When is Election Day? Is it defined as the day the ballots are marked by citizens or received by election officials? That is the heart of the question in the case Watson versus RNC, and the court's decision will impact more than just Mississippi. So let's take a look at this case next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach Rise and Generation be free. Glad you could join me today. This question of Election Day for, decades was not a big deal. There was a day when people voted, submitted, and those votes were counted. That's not the case anymore. So when is Election Day? Is it the day you write in your vote? Is it the day you place it in the mail? Is it the day it's received? Is it the day it's counted? That's what we're going to dig into as we get into this case. Now, if you want to follow along, head to the website, constitutionstudy.com. Find this article. I've got links to all my sources in the article. And you can follow along and check, make sure I'm following along correctly. We'll talk more about the website and what you can do there at the end of the episode. But for now, let's take a look at this case, Watson versus RNC. We start, as most cases do, at the beginning. The federal Election Day statute set the day for the election of representatives, senators, and the president on a Tuesday in November. Now, one problem here is that the federal election day does not include the election of president. We, the people, do not elect the president of the United States. The state legislators appoint electors who do that. Now, the states have decided to appoint said electors based on the popular vote of their people of their states, so the court is not off to a good start for this decision. Mississippi permits certain residents, such as college students away from home and senior citizens, to vote in federal elections by absentee ballot. Mississippi is one of roughly 30 states that count at least some absentee ballots mailed by Election Day, but received afterwards. Absentee voters in Mississippi may dispatch their ballots by mail or common carrier, and all absentee ballots must be postmarked on or before the date of the election and received by the registrar no more than 5 business days after the election. Now, under Mississippi law, mail-in ballots can be accepted as long as they are postmarked by Election Day and received within 5 business days after the election. Does that follow the Constitution and laws of the United States? In 2024, the Republican National Committee, the Mississippi Republican Party, and various individuals sued the Mississippi Secretary of State and several election officials, contending that federal law prevents Mississippi from counting absentee ballots received after Election Day. According to plaintiffs, the Election Day statute used the word election to refer to 2 acts, ballot casting and ballot receipt. So by setting the day for the election, these statutes set the deadlines for both. The Libertarian Party of Mississippi filed a similar suit, and the district court consolidated the cases and then granted summary judgment to Mississippi. The Fifth Circuit reversed, holding that Mississippi's statute is preempted because the federal Election Day statutes require ballots to be received by Election Day. So the real question in this case is, does Election Day refer to the day the ballots are cast or the day they are received? The district court agreed with Mississippi while the circuit court reversed that decision. Let's take a look at the details of the case. Now, we need to remember the question before the court is pretty narrow. The question before the court is narrow: whether counting ballots postmarked by Election Day but received up to 5 days later violates the federal Election Day statute. Plaintiffs do not challenge the general practice of absentee voting, the use of postal service or common carriers to transmit ballots, early voting, or the counting and certification of votes after Election Day. The court also does not consider the scope of Congress's authority to regulate federal elections. Well, isn't that interesting? The court has decided not to consider the scope of the very laws they are reviewing. How can the court decide whether or not the Mississippi law violates federal law without determining if the law made by Congress was made pursuant to the Constitution? Otherwise, that federal law would not be the supreme law of the land and, in fact, should be considered null and void. The federal Election Day statutes do not preempt Mississippi's law because the defining element of an election has always been the elector's choice of candidate. Is that the full definition of an election? Because according to Webster's 1828 dictionary, an election is The act of choosing, choice, the act of selecting one or more from others, hence appropriately, the act of choosing a person to fill an office or employment by a manifestation of preference as by ballot, uplifted hands, or via voce, as the election of a king, of a president, or a mayor. Is the act of choosing complete before the choice is recorded? In other words, is the election complete before the votes are counted? And how can the votes be counted if they haven't even arrived yet? In a related federal statute, the Uniform and Overseas Citizens Absentee Voting Act confirmed that while federal law dictates when ballots must be cast, state law governs when they must be received. Interesting, because I took a quick look at UOCAVA, and it does generally follow state deadlines except for when delivered by United States Postal Service. Except as provided in subparagraph B, the deadline described in this paragraph is noon in the location in which the ballot is collected on the 7th day preceding the date of the regularly scheduled general election for federal office. If the presidential designee determines that the deadline described in subparagraph A is not sufficient to ensure timely delivery of the ballot under paragraph 1 with respect to the particular location because of remoteness or other factors, the presidential designee may establish as an alternative deadline for that location the latest date occurring prior to the deadline described in subparagraph A, which is sufficient to provide timely delivery of a ballot under paragraph 1. Even if the presidential designee determines that the deadline isn't sufficient for a specific location, they can choose an alternative. However, that alternative must occur prior to the deadline of the 7th day preceding the date of the regularly scheduled general election, meaning that ballots must arrive before Election Day. That still leaves us with the question about when an election is complete. The electorate's choice is made when voting is complete, not when ballots are received. The most recent amendment to the Presidential Election Day statute bears this out. While inserting the phrase Election Day into the statute and marking that date as a specific Tuesday, Congress also provided that when states modify the period of voting in response to some force majeure event, the term Election Day shall include the modified period of voting. That's shown in Title 3 U.S.C. Section 21, Sub 1. Now, I love it when people, especially judges, contradict their own arguments. Because as the court noted, under 3 U.S.C. Section 21, states can only modify the period of voting when the state appoints electors by popular vote, which is every state, if it is necessary by force majeure, which is an event that is a result of an element of nature as opposed to one caused by human behavior. So under this law, states can only extend the election day in response to a natural or otherwise extraordinary situation. Mississippi law is not force majeure. The court also ignored the fact that the law they are quoting only applies to the appointment of presidential electors. Finally, this interpretation is consistent with the Constitution's requirement for the Electoral College. The Constitution requires the day on which electors shall give their votes to be the same throughout the United States, but says nothing about the day for receipt. Except the quote the court took for this example is not Election Day, but a day for the electors for president and vice president to give their votes, which is in December. The Constitution states not only that Congress sets the day on which presidential electors vote, but the day they are chosen. And that, according to 3 U.S.C. Section 1, is the electors of president and vice president shall be appointed in each state on Election Day in accordance with the laws of the state enacted prior to the election day. How can states which choose their presidential electors by popular vote do so on Election Day as Congress established if their elections are not counted by that date? The Constitution thus envisions a system in which receipt of votes is necessarily divorced from voting, and it sets the crucial uniform day as the day of voting while leaving receipt to happen later. The Federal Election Day statute followed the same pattern. Nothing in the Constitution divorces the act of casting a vote from its receipt and counting. Then again, nothing in the Constitution explicitly states that an election includes the casting, collecting, and counting of ballots. Now, Justice Alito disagreed with the majority opinion. Justices Thomas and Gorsuch joined the opinion in full, while Justice Kavanaugh joined in part. For more than 100 years, federal law has designated the Tuesday next after the first Monday in November as the day on which United States senators and members of the House of Representatives are elected. That's 2 U.S.C. Section 7. Setting the date as a day for the election of members of the House of Representatives. Section 1, United States senators shall be elected on that same date. Similarly, federal law has long provided that the electors of president and vice president shall be appointed on that date as well. That's 3 U.S.C. Section 1, subsection 2. And because the appointment of electors in each state is now decided by popular vote, voters express their preference for president on that same date. So far, I think all parties agree on these facts. However, by pointing out that electors of president and vice president shall be appointed on election day, Justice Alito does add a new twist. See, although the states decide which electors to appoint based on a popular vote in the state legislature is still required to appoint electors on that date, which cannot be done if they're still waiting for ballots to arrive. As the court explains, an election is the expression of the electorate's choice, but because the electorate is a collective body consisting of many individuals, the way in which it expresses its choice is less straightforward than would be the case if the electorate were a single individual. If the electorate were an individual, it could issue a document declaring that the specified men and women were selected to fill federal offices for which they are candidates and competed. But because the electorate is a collective body, it cannot express its selection in that way. Instead, its choices are embodied in the collection of ballots cast by the individuals who make up the electorate. Taken all together, this collection is the equivalent of a single document declaring the winner of each race. Now, if an election is the act of choosing, when is that choosing complete? How do we know what the collective choice of the electorate is until the ballots are not only cast but counted? And how can they be counted if they're not yet received? This expression of the electorate's choice is conveyed to the responsible election officials when the collection of individual ballots is completed. At that point, the electorate authoritatively expresses its choice, and what the Election Day statute demands is that this authoritative choice be made on Election Day. Now, if ballots received after Election Day are added to the set of ballots that dictate the election's outcome, the electorate's choice does not occur on Election Day, and the federal Election Day statutes are violated. According to Justice Alito, the election isn't complete until the votes are collected, and that is when they are officially cast, which is a problem for Mississippi law. In this case, we must apply this interpretation of the federal Election Day statute to a Mississippi law that requires states' election officials to accept ballots that arrive up to 5 days after Election Day. The acceptance of these late arriving ballots effectively postpones the date on which the elector's choice is made, and federal law precludes that postponement. Justice Alito believes Mississippi's law violates federal law because ballots can be accepted after Election Day. But there's a little more to this decision. Election Day is a specified date, not a span of multiple days. The Election Day statutes require that federal elections occur on that date. Under the challenged Mississippi law, however, the collection of ballots continues for 5 more days, and therefore the election is not held until the end of that period. Because federal law requires that the election occur on Election Day, it preempts Mississippi statute. Justice Alito is wrong in one point. Federal law does not preempt state law because they are different, but because of the supremacy clause of the Constitution, which reads, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." Is there a historical basis for Justice Alito's position that Election Day must include both casting and collecting ballots? 2 centuries of historical practice reinforce the proposition that holding an election on a particular day means that poll workers have to receive the ballots by that date. From this country's founding until the late 20th century, Election Day ballot collection was the near uniform practice, with only few late-arriving exceptions. Before the Civil War, nearly all voting occurred in person at polling places, so Election Day was, ipso facto, the day on which the poll workers collected all the ballots. If, at the time of the ratification of the Constitution and the passing of federal laws on the subject, an election included not only the casting of ballots, but collecting of same, it would appear Justice Alito's position is a correct one. For this reason, I would affirm the decision below, which held that the provision of Mississippi law requiring acceptance of late ballots violates federal law. Because the court reverses that decision based on a flawed understanding of Election Day statutes, I respectfully dissent. Which of the 2 positions do you think is a flawed understanding of Election Day statutes? Now, how did the court decide this case? Held. The federal Election Day statutes do not prevent Mississippi from counting absentee ballots postmarked by Election Day, but received up to 5 days thereafter. Nothing in the federal Election Day statute requires ballots to be received by Election Day. Now, the majority of the court sees Election Day as the day ballots are cast, as opposed to the dissenting judges who wrote, "Having considered text, legal context, and historical practice, I turn to precedent. Although few judicial decisions interpret the Election Day statutes, those precedents favor respondents' position. The dissenters believe that Election Day is not complete without the receipt of the ballots. However, since it is the majority who decides the case, their viewpoint wins the day. The framers recognized the difficulty of crafting election laws applicable to every probable change in the situation of the country. That's from Federalist 59. So instead of constitutionalizing election law, they decided that a discretionary power over elections needed to be lodged somewhere. Suffice it to say that power is not lodged in the court. The Election Day statutes say nothing about ballot receipt, and we cannot add to the words Congress chose. The judgment of the Court of Appeals is reversed, and the case is remanded for further proceeding consistent with this opinion. It is so ordered. Now, how do I view the case? I've been leaning against the Mississippi law since the beginning of the case, but not primarily because of the Election Day controversy. Mail-in ballots have a lot of security issues, which is why I have only mailed a ballot once in my life, when I was out of state for weeks before the election. With the efficacy of the postal system, I'm wondering why people need to wait until the election day to cast their ballot. It's like playing chicken with your civic duty. And since the mail-in ballots are mailed to the person one business day after they are successfully requested, I don't see the logic behind waiting to the last day to cast it. On the other hand, I do see some of the logic of the majority of the court. The Constitution places the responsibility for setting the time, place, and manner of electing members of the U.S. House and Senate squarely in the hands of the states. Yes, Congress can modify most of those laws, but the idea was clearly for the states to control the elections. That is what Mississippi has done, but there's a problem. The law specifies a date for election and does not distinguish between the casting of votes and their collection. As Justice Alito pointed out, that's because it was only recently that there was an opportunity to distinguish between those two events. So to determine my opinion about this case, I use Occam's razor, the idea that the simplest solution is probably the best. Election is defined as the act or process of electing someone to fill an office or position. Since the act or process of electing someone to fill an office or position requires not only the casting of ballots, but their collection and counting, Election Day must include all three parts of the process. While the majority focus on casting of mail-in ballots being the day they enter the postal system, they ignore the plain definition of the term cast as related to ballots. To deposit or indicate a ballot or vote. When someone deposits their ballot in the mail, have they truly deposited them to be counted or merely to be delivered? Ultimately, since mail-in absentee balloting is an accommodation under Mississippi law, I do not think it's unreasonable to ask that the ballots be delivered by Election Day. But Mississippi gets to set its own time, place, and manner for elections of House and Senate. The real problem is the state's duty to appoint electors for president and vice president by Election Day. That means if Mississippi wishes to persist in a popular election to determine those electors, those ballots need to be in and counted by Election Day. And since the Constitution delegates to Congress the power to determine the time of choosing electors, Mississippi cannot change that, even by law. All this rigmarole, all this craziness, all because people can't be bothered to actually show up to cast a vote? I agree, there are times when absentee balloting makes sense. Like I said, I've done it exactly once in my life. I was literally out of the state for the weeks before and after Election Day, so there was no way I could cast a ballot in person. It's the only time I've ever done it. But how much accommodation do we need to make? If you're making an accommodation by allowing them to vote by mail rather than in person, do you really need to extend the time they have to cast that vote? And really, if I'm casting a vote, that means I'm depositing a vote, is depositing it to the Postal Service actually casting my vote? Or is it when it's deposited with the election official? That's a good question, one that I didn't see covered by the court. That's why personally, I think in general, I agree the state should set their own election day for House and Senate. However, they can't for president. And that's where I think Mississippi's law runs afoul of U.S. law and the Constitution. Because you have the legislature of Mississippi cannot appoint electors for president until at least 5 days after Election Day, which violates federal law, which is the power of Congress to set the day for choosing electors. Now, part of this is all lost because most people, even the court apparently, doesn't realize that the people don't vote for president or vice president, but that's a whole other issue I've covered multiple times before in this program. To me, I think the court got it wrong, not as blatantly wrong as some say, and not for the reasons that even the dissent says. I think the dissent has a point. I think the majority has a point when it comes to House and Senate. Problem I run into is presidential electors. That to me is the sticking point they've got there. And well, that's my opinion. That's how I looked at this case. Now, if you'd like to find out more, again, head to the website, constitutionstudy.com. You can find the article. You can check all my sources. You can even ask me a question, post a comment. There's a whole section on asking questions, and I will answer to the best of my ability. That's what I love, answering questions here. That's what I'm here for, to educate, and that works best by answering questions. You can also go to constitutionstudy.com/questions, ask a question, or email me questions@constitutionstudy.com. I do my best to answer the questions as quickly as possible and with as much information as I can. All I ask is that you be polite and that it be something to do with the Constitution or Constitution study. I've been getting recent questions about legal issues that I'm not qualified to answer. I'm not an attorney. I don't play one on TV. Now, I also hope you'll support the work we're doing here by going to the store, constitutionstudy.com/shop. Maybe buy a book or a t-shirt or just donate to the cause. Nobody takes a salary here. We pay for all of this. So if you can help, well, that'd be greatly appreciated, especially remembering that when I go to do events, when people ask me to come speak, the only way I can afford to do that is either charge them or rely on your donations. So when you donate to the Constitution Study at that website, you're also helping me to bring this message to other people without having to charge for them. Again, that's constitutionstudy.com/shop. Of course, you can also support the work we're doing here with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. And although they do some really great work, they've got great 4G and 5G coverage. They've got 100% US-based customer support. I join them because they take a portion of every dollar to support organizations like the Constitution Study that are fighting to protect your rights. So when you go to patriotmobile.com/constitution, find a plan that works for you. See if you're eligible for a discount. Veterans, first responders, even families with multiple lines are eligible for discounts. And when you pay your cell phone bill, you're helping to support the Constitution Study and organizations like us that are helping to fight for your rights. So you get good cell phone service, good prices, and discounts, and you support people that are protecting your rights. Only if you go to patriotmobile.com/constitution, sign up for a plan today. Most of all, I hope you enjoyed the content we have here. I hope you enjoyed this program enough to share it with friends and family, maybe a neighbor, and who knows, maybe invite some people over next time we get together for the Constitution Study.